Introducing the all-new Corolla.
In her decision issued yesterday, Chief District Court Judge Frances Tydinko Gatewood expressed her frustration with the governor's legal representatives, attorneys Sandra Miller and Roland Mantanotnya, over their blatant refusal to work with federal receiver Gershman, Brickner, and Bratton. As a result, she is now allowing GBB to hire its own attorneys and to pay for it with the $4.5 million the Guam Solid Waste Authority has been using to reimburse the government of Guam. The court finds the actions or lack thereof taken by the legal team of the government of Guam, Ms. Miller and Mr. Mantanotnya, to be unacceptable, she writes. Instead of moving forward in this process, their actions appear to obstruct, delay, and thwart the receiver's efforts and the efforts of the new GSWA board to complete the tasks under the consent decree. Federal receiver Gershman, Brickner, and Bratton Principal Associate David Manning was on the K57 Breakfast Show this morning with Ray Gibson. Here's what he had to say.
It's really unfortunate that it's come to this because the Attorney General's office did an outstanding job. There was no conflict of interest as has been alleged by the governor's office.
How much of that $4.5 million will actually be used to pay for legal counsel, Manning says, is ultimately up to the government of Guam.
Well, that's really up to the government of Guam. Certainly the legal fees will eat up some of it. And it's hard to speculate as to how much that might be, but we all know private lawyers are not cheap. But I think the court has given us clear direction, which is what we asked for. And we'll proceed in a way as best we can that minimizes cost to the government of Guam.
The judge accused Miller and Mantanotnya of refusing to assist the receiver, whether on the ORDOT land condemnation actions or the RFP review, or to even meet with the receiver to discuss the Lagu settlement or to discuss financing other projects. She called their actions a disservice to the government of Guam, the GSWA board, and most especially the people of Guam. She pointed out in her decision that the government of Guam fought feverishly to have the AG replaced by the Cabot Mantanotnya firm, and even assured her that doing so would not delay the case. Clearly, this is not the case, she said. She chided Mantanotnya for hiding behind the rules of professional conduct to shield himself from having to work with the receiver. And she warned that the federal court will not tolerate the unprofessional tone and tenor of the language used in the letters and pleadings they wrote. Attorneys must still demonstrate respect for the law, and the court expects counsel to treat each other with a high degree of civility and respect and must not lower their professionalism.
The court's frustration, I think, is shown in that order, and is that the government of Guam is treating us as if we were an adversary, when in reality, the government of Guam agreed to do all of this, and they have to fund it.
Judge Gatewood also noted that ratepayers could suffer as a result because the general fund will no longer be receiving the $4.5 million annually from GSWA for debt service. This decision could have been avoided, she says, if the administration simply withdrew the requirement for the additional projects it requested or to work with the receiver.
We are comfortable with the rate structure as it exists today. We don't need any more money from ratepayers, but the government of Guam has to decide whether it wants to raise those rates in order so that it doesn't have to use Section 30 money. Or whether it is going to leave it as it is. And that is a decision, frankly, that people who are elected in Guam should make, not something the receiver should make.